That being said, let's talk to one of the Warrior victors, our good friend and fellow Warrior, Paul Toledo. Welcome to the show, and thanks for being here. I'm going to get your clients on as well.
Thanks,
Michael. Let them talk. I think there's no Fifth Amendment that needs to be taken here. Welcome, Amstos. Is this Jim and Deb on the phone?
Yes, we're here.
Welcome to the show. First of all, let me just say congratulations. Everyone's been following the case. Kind of a historic, and especially I know that there was a tremendous welcoming of the local community to your facility and the things that you were doing there. Again, one of those towns that there was no complaints by the local communities. It was completely a outside element that came in and had objection to the behaviors. But it's been a long road, and I just want to offer you my deepest congratulations. And I think everyone feels that way. We're so happy for you. Paul, brilliant lawyering. Let's ask you some questions because I think people are fascinated. I talked a little bit about the opinion.
Thank you for that, Michael.
My pleasure. I'm glad to say it any time. Paul, tell us a little bit about the the challenges here. This is all pre-Section 8. This is still obviously after the bind over, but you're up in circuit court and you're arguing the law essentially.
Ultimately, yes. The way that the judge wanted it is she wanted to have the motion submitted at a certain time and to be heard at a certain time. So there was one day set aside for all the motions. So we had to submit them all. Everything had to be in. Responses had to be done. And we came back actually to hear some of the motions. And
were you scheduled to do your Section 8 hearings on those days too?
Well, what had happened is when we had filed the motions to dismiss based on the Section 4 and Section 8 challenges, the judge said at the next court hearing before the actual hearings of the motion, that the next court hearing she says, well, I pretty much have to give this to you, so let's just schedule it. And that's the same thing happened for the entrapment by estoppel motion and the regular entrapment motion. The judge just said, I pretty much have to give this to you. Do you guys agree? And no one disagreed, and we picked a date for it, which was today and yesterday, actually. So the motions that were challenged or didn't require automatic evidentiary hearings were then set to be heard at a later date. So when we came back, we had a chance to respond and a chance to air these motions out. And I think the way that it went is that anybody who wrote a motion either had it denied or taken under advisement or
could you do
set for a hearing.
Paul, please do us a favor, would you, and turn the volume down on the computer that's in the background that's playing the show. It's because it's giving us a lag. It's a little confusing. But then please pick right up where you left off. I apologize.
Oh, it's not me. I don't have it on.
It's us.
Oh,
but
fantastic.
we turned it down.
Thank you, Paul. Please go ahead. Thanks.
Okay. Sorry. So the motions that were filed were either taken under advisement, set for evidentiary hearings, or denied. So I had a search warrant motion denied. I had a malicious prosecution motion denied. The AG filed what they call it's a GECI motion. It's essentially to reinstate the charges by giving the circuit court judge appellate review, but it's still a abuse of discretion standard, like it would be for a motion to quash, like the defense would do. And then there was a 404B motion. So there was a lot of motions actually filed, and she said that she would take the motions to dismiss based on ultimately the due process arguments and the ex post facto arguments, take that one under advisement, and then she set another one for evidentiary hearing and dismissed the rest.
I mean, denied the rest. Denied
the rest, correct. Denied the rest.
So it's like you're saying, all the other, so she took the ex post facto one under advisement, all the other legal arguments, the search warrant, the entrapment, she just denied, And then
the
you're
entrapment was set for hearing, but all the
Okay.
malicious prosecution, the other ones, she just denied them. And it was, you could tell, the first couple minutes into the argument, you can kind of tell where she was going to lie on it, and she did. And it was fair. I mean, I figured she kind of went both ways, and she kind of knew what was. She went with some slam dunk stuff, and she dismissed things that were close calls, I guess, but or just denied things that were close calls. So I was actually kind of, I don't know, I guess surprised that it came this late. I mean, I got the opinion about 5:15. All of my witnesses had left work. I had no way of contacting them. I had witnesses show up in court yesterday morning, and they called me. And
you were planning on commencing the Section 8 hearing, right?
I was, I had witnesses lined up and the whole bit. I was ready to go.
Right.
We were ready to have the entrapment by estoppel hearing, and then have the entrapment hearing, and then have the Section 8 hearings. All, we had 2 days scheduled, but it would have taken much longer than that. So.
And that's always one of the things I think. Instead of having to sit there and listen to all that, it'd be better that you just threw it out, right? I mean, there are judges that think like that. Unfortunately,
right.
You know what?
Or at least give me a little bit of heads up. At least give me, don't take me to, the eve of it before you throw it out.
All right, so we didn't get to Section 8. We got it. So let's zero in on this. And I'm sure you would have gotten a dismissal with a Section 8 hearing anyways, right? That was not even an issue. All right, but just, anyways, returning to this opinion. This is a very interesting opinion. There isn't a lot of judges that I think would do this. Paul, you would agree with me? And I
would agree with you.
I was trying to delineate earlier the distinction of a law that has been, legislated by the legislative branch applying retroactively. It's much easier call to say that's not allowed. I mean, that happens. I think even a prosecutor would agree with that. For example, the amendments of 2013 should not ever apply to culpable behavior that existed before, right? But
correct.
The law, the rulings of the Court of Appeals and the Supreme Court, it's still debatable. In fact, she even kind of dances around it a little bit in her opinion, doesn't she? She suggests that ex post facto doesn't apply to the judicial branch except for its connection via due process. She's kind of saying this is not fair, and I'm going to find a reason to get this case dismissed. Am I missing something there?
No, I think you're right on that, and I think the reason she does that is to, put her foot down firmly in the tread she's about to go on, and I'm okay with that, because the more that she explains how she got there, the better it is when it comes to challenging it or trying to appeal it.
Right.
Because,
agreed.
And that's the same thing. It's like there's so much good reference to the cases like Doyle and like Dempster, and by pointing to them and using their language and saying this applies for these reasons, it gives it a lot of weight. And I think that the analysis and the depth that she took to look at this, which is, this is one of those opinions where just like, okay, no kidding, we thought the same thing, and now you're just finding a way to put it nicely into 4 pages of legal opinion.
Well, let's talk about that. It's always good to see when these judges take the time to think these things through, right? I mean, it's you don't always get that. Sometimes it's just like, I don't understand. You'll agree with me, Paul, that sometimes an error that a lawyer may make would be that we presume that the court understands the law to which we're arguing about, and they're following.
I think that's our biggest error a lot of times, is that we presume that they're as smart as we are, and because their heads are so full of a lot of things all at once throughout the day, they can't. They need the help to bring the magnifying glass to the attention of the detail that we're trying to look at to make the difference that we know to exist, and that's oftentimes the hard part, because no one wants to hear that sometimes. No one wants to be schooled or educated or be have their time wasted being taught something while they're on the clock. But the other thing about this opinion is that this was not necessarily the first judge that I would have picked to have written something like this in that building. I think there were as far as situations, Michael, that you go into and you know that you've got a good judge right off the bat, or you know that you've got a bad judge right off the bat. This was a situation where, I thought she was kind of right down the middle, but I didn't expect her to, let's say, be this brave.
Well, let's talk about that for a second, because it is a brave. Now, one of the things that let's look at, because when you say brave, I know what you mean, but I don't know that everybody else does. What does that mean? I mean, there's a perception amongst the judiciary by prosecutors whispered, that this is a joke, right? That there's no such thing as medical marijuana, and that anyone get a card, and that if you let one of these defendants get away with some of those shenanigans, you've had the wool pulled over your head, or you've been fooled. I mean, I almost think that's the way that they feel in Oakland County. So when you say brave, she's saying it's her standing up and seeing it for what it is and calling it for what it is, and not being affected by, the crowd, so to speak. But I don't know if this helps or hurt the position I'm taking for her, but it's not a medical marijuana decision per se. You know what I mean? She didn't find the law. It is a due process constitutional one, which is an easier path for many of these judges to take in terms of her legal ruling. Would you agree with that?
I would agree with that. I actually think it makes it a better decision and a more grounded decision rather than sort of being a self-contained medical marijuana decision. It is a statutory and constitutional decision. It's a regular legal decision, and it's not making a distinction and not necessarily prejudicing the defendants by just saying, "Oh, this is only a medical marijuana issue. You violated it. If you do, you're in the criminal realm, and be warned," like some of the Court of Appeals cases have done. And that's actually part of some of the language that you haven't even seen a whisper of in some of these higher court opinions. That has to do with that. It says here, although the MMA does not impose criminal sanctions, failure to meet its requirements may and likely will result in the filing of criminal charges against non-complying persons. So by saying ultimately there's no contained penalties in there, it would be unfair to say that you go back and look backwards and now apply criminal penalties to this behavior. So there's a lot of, like I said, she's putting her foot down on a lot of different issues to gain traction.
Let me draw that out a little bit, because I want to ask you something else, but that's kind of interesting. You're suggesting that there's an argument here of whether or not the behavior is actually being assessed as a violation of the Public Health Code or a violation of the Michigan Medical Marijuana Act. That's one of the inherent arguments in here. That there's notice, there's due process given because marijuana has always been illegal. It still is illegal. It's just a question of whether you're immune from arrest. But still, even if that's the case, the behavior that would be considered one would be immune if it had not been declared. There had been no official declaration. This is one of the things that there's two or three things I want to talk about. But let's just go down this road for a second. In order to get to this conclusion, this judge seemingly suggested that before McQueen, correct me if I'm wrong, that any caregiver to any patient, independent of connection through the registry, was a interaction that was immune from arrest and prosecution. Did she take that position?
That's what it sounds like. It sounds like 4E provides the protection of a patient to a caregiver or a caregiver to a patient, and able to receive compensation. So, and even better is that she points to that and says, okay, there's no way that you could have interpreted any other way other than the way it's written, and you couldn't have foreseen the McQueen Supreme Court telling you that that's what it meant.
Well,
so it's not fair.
McQueen doesn't even address 4E, does it? It doesn't really.
No, but it addresses the a and the ultimately.
I understand, but I'm saying it's just interesting that. But anyways, beyond that, I was thinking about this earlier. What was the state of the law at the time? Are you relying upon the Chamberlain opinion at the trial court? Are we relying upon the Court of Appeals in McQueen? And then even knowing those two things, how could anyone predict as seemingly what she suggested? I wonder if she took all those things into consideration in terms of the behavior. Because it seems as if she's got to accept that the behavior was lawful or able to go on, which I guess that would be. Was there any kind of local approval? There was a license offered by the local government, and wasn't there some kind of?
Yeah, there was an ordinance, and actually,
right.
I think Jim and Deb helped them write it.
Right.
So, there was a lot of, like I said, there you had to look kind of far to find enemies. This isn't, and none of my investigation did I ever find anybody who thought it was good that they were being prosecuted for it. Most people are just like, oh, that's too bad. There's just, it's, the same opinion of how wasteful such a thing is and how unfortunate it is to have to go through such a thing. And I'm curious, and maybe Jim and Deb can chime in on this too, is I'm curious to hear what the response has been and what people have been saying, because, for Michael, for you and I, this is a big deal because you get a judge to make the right decision. So that's like a little bit of a lawyer's celebration. But that's, small by comparison to the people who this affects. So I'm curious to hear what kind of responses you guys have gotten, because I'm sure it's been a big reception.
Yes, let's get back to Jim and Deb. First of all, again, congratulations. Tell us about how have things been received in the community?
Paul, Jim,
yes,
Deborah's here. We love you.
Thank you. Love you back.
You're the best. We're still cavitating from this win. It's been an emotional roller coaster. The community is standing up, saying this was the right thing. I'm glad I voted for this judge. We've had comments come to us from people who are not medical marijuana patients or caregivers or use medicine at all, and said the judge has done the right thing today. We voted for something that these people were doing nothing wrong with. So the community has exploded here in St. Clair County, Sanilac, Tuscola, all three counties that they decided to do this to us have embraced us. So we're moving forward. We're still at awe with this. Paul, as yourself, what we've gone through.
Oh, yeah.
Matt Newberg, we'll give him all the credit here, too.
Oh, yeah.
He fought long and hard, but everybody's got to remember Paul Talinda fought the hardest. He's been by our side for a year and a half fighting this case. Before that, because, Paul, we went through the Tuscola County case with me driving under influence.
Hey, we won that case, too.
And we won that case, too. That went to a jury for you folks. We were the first to put it to a jury, and they found me that I was not under the influence, and that was a day before I opened my Tuscola facility. They pulled me over that night when I left there from working there and getting it set up. So they pulled me over, and the prosecutor there said to take me to jail because the officers smelled marijuana. Well, there was 4 medical marijuana patients in the car. So, and you know yourself, Paul, they offered us a lot of deals.
Oh, all the time.
One thing I want to say, and I mean, you looked at me a couple times, but you know where I go.
Oh, yeah.
And I go to the jury.
Yeah, that was a lot of fun. That was a Kuhn case. That was right after the original Circuit Court Kuhn opinion came out, and the judge bought the reasoning and allowed us to present it and made him prove intoxication, and they weren't able to.
Nope, but they didn't let us present the Medical Marijuana Act.
No.
But the cop made a copy of my card, and we got to show the jury that medical marijuana card. And folks, as you're listening tonight, when me and Paul walked out of that room and talked to the juries, the first thing that come out of their mouth, besides Mr. Amstel, you had a medical marijuana card. You were legal to use this. And that's what the jury said.
Yes.
So as today, I feel relieved that this is all done and over with. But in the same sense, Paul, I think you know how I feel.
I know.
I wanted that jury to say my family was not guilty.
Yeah.
And then we would have been done with this forever.
Right, rather than facing a potential appeal or
Right.
whatever they're going to...
Can't appeal, they appeal not guilty, in other words.
Right, they can't.
By the way, it makes sense, and, Paul, the circumstance of trying that driving case is interesting because we've kind of gone full circle now, right, in terms of that's where we're at right now. We had one out in Livingston County where we couldn't argue, even mention the card. Of course, it came out in various times and weird things happened, but that was a crazy time, and that's something I wonder whether or not trying to exclude it when you really can't has what kind of impact it has on how the jurors are going to view it. If it sounds like someone's trying to keep something from them, but nevertheless, I just wanted to return to the opinion a little bit because it fascinates me about this one little interchange here. Wait, did you guys have oral arguments on this, or did you just submit your briefs?
We did have oral arguments on it. That's what she heard it. We argued it, and that's when she took it under advisement.
All right, so I want to cover this part on the fourth page where it says, as a general rule, judicial decisions are to be given judicial decisions are to be given complete retroactive effect. However, if a judicial decision is unexpected and indefensible in light of the law existing at the time of the conduct, retroactive application of such a decision is problematic. As a result, it has been stated that an unforeseeable judicial enlargement of a criminal statute applied retroactively operates precisely like an ex post facto law. So I would imagine that some of the arguments that were being made resulted around, and these are the elements I'm assuming in terms of what is to be decided in terms of, whether it's unexpected or indefensible. I'm sure there were some arguments in terms of those things. Was there, because there's obviously this is a point that she flexed in her opinion and made took kind of a dug in on.
Right.
How did they argue about that?
It's funny because there are parts of this when I read through it. There are parts of it that I think that this opinion is ultimately based on all of the arguments that she heard that day in all of the motions, and then said, okay, I'm going to build off this ex post facto stuff, but I'm going to sort of build this with all of these side issues, because when I read this, I think she uses this as, again, it's a foothold. She's saying, hey, you might challenge me on this issue. You might think I'm forgetting about retroactive decisions, and I'm not. And I'm telling you, here's why it doesn't apply for these reasons. And I'm telling you it's unexpected, and because it's unexpected, it's unforeseeable, and it's a due process violation. So she weaves a very interesting web that, let's say that, there isn't something in here that if you take out one part, the whole argument falls apart.
Right.
There's a lot that she rests on to say, hey, look, this decision was built and gotten to logically, but it also, for me, it has the undertone of, really kind of calling it bullcrap, really kind of saying, hey, look, everybody kind of knows what's going on with this case. The fact that they're acknowledged as patients and caregivers right out of the gate is good. I mean, they give them a status, and I think that the understanding that much like in the district court level, where the district court judge acknowledged that, hey, this is not a fly-by-night organization. This is not selling, drugs out of the back of your house. This is storefronts and proper businesses, and the only people who are getting through those doors are people with cards and people who are supposed to be getting through those doors. So, without finding any real grievous action, I think the judge really picks up on that in this opinion, is to say, hey, look, this really isn't, it seemed like it was okay. We thought we could do it. And now you're going to tell me you can't? That doesn't seem right. And that's good.
Let me ask you this. Of all the different legal arguments that were coming into being in whatever questions may have been asked during the oral arguments, and I'm taking it that she seemed to be prepared for the motions, like she'd read the material. Okay.
Yes.
So did you get a feel from her that she wanted you to direct your energies towards the ex post facto issue, or did she not give away her hand? I'm just curious.
On the ex post facto stuff, it seemed like she was very receptive to the arguments. Like it sort of, I guess looking back on it now, I could say perhaps she was looking for a little bit of meat on the bone, and I think the oral arguments gave that to her. Throughout the rest of the motions, her general position, which I actually kind of liked as a judge, was her general position was convince me. Give me something I can point to. Give me something I can hang my hat on. And when you're, able to give her that, she was fair.
But so that's because you know what? I get the feeling that, they know that it's political suicide to do otherwise. Am I right?
Uh-huh. Yep.
Like I think like the influence of the community here had a lot to do with it. Like her peers became less important than what the spiritual belief was of the community. Do you sense that about her?
I did get the feeling of it that she really became like a guardian of the community, which sounds kind of corny, but which isn't that what a judge is supposed to do? And the judge made the decision to say, ultimately, it seemed okay in St. Clair County, and we were just fine until the AG decides to show up and bring this case into our court. So because of that, I'm going to tell you, it's not fair that you did that.
Well, one thing on this, though, Paul, is in that motion was when you hit her with the change of the drinking age. When she says, this is like the change of the drinking age, huh? Right. We just all happened that me and Judge Lane were in the same year. I got to drink for 3 months, and the law changed to 21 again, and I didn't get to drink for 3 months. And she caught on to this. Wait a minute, they didn't charge me for those 3 months I got to drink.
Right.
And then they changed the law, and then the seatbelt. Then she threw the seatbelt at us.
Right.
So
that's I was telling her, and that's when she said, "Oh yeah, I drank when I was 18," and I thanked her for her admission, and then I told her about the seatbelts. And that's the thing that's what I was saying is that she was looking for meat on the bone. She was looking for something to prop up the argument, to kind of solidify it in her own head, because, and this is an issue I've had this conversation earlier, is something like this is sometimes just a punt. And Michael, you know what I'm talking about, where a judge just says, "Okay, get this out of my courtroom. Let somebody else make the decision on it. And then if I got to bring it back, then at least I have guidance on how to handle it."
Well, we talked about this with some of judges out in the Oakland County area, that their position would be, under no circumstances am I going to utilize this law to dismiss a case. I would rather dismiss it for some other reason completely unrelated to the prosecution, or I'm just going to rule against you every single time and let the Court of Appeals tell me that I have to enforce the law. The political environment, though, is different because you have a greater acceptance of medical marijuana. There's a local acceptance and statewide, and no issues other than this external force that's calling it a bad thing. But they don't live there. They're not their people. They're just some critical external factor. And she's doing. I'm sure there's very few, if any, of their St. Clair County, narcotics teams. This is all MSP. So she's not hurting any of them, and any of the sheriffs that are her people, it's not hurting them. It's kind of like, and she's taking care of the voters to a certain extent who are benefiting from it. So, there's a lot of things that kind of align. I'm just, as we play Monday morning quarterback, taking nothing away from the legal arguments, but the point that you're talking about is she's saying, look, I ruled, what I thought was fair. Let someone overturn me, and if it's going to happen.
What a thoughtful decision, though. It was really well articulated, and I think Paul's right. This could stand up to any Court of Appeals scrutiny.
Well, and that's the thing is, other than the fact that they'll probably just say, "Oh, we're going to review this de novo and we're going to turn it around," she gets them with enough basic law and just basic principles that they have a lot to overcome, and these aren't just weird technicalities. But the way I look at this opinion is, the Court of Appeals will probably find a way to weasel out of it, and the Supreme Court will probably find a way to reinstate it, or at least something close to it. And that's,
one of the significant things about this for all that are listening is this is like a one-time, pass, so to speak. This isn't something that can be used really ever again in terms of, a date, an alleged culpable date that precedes McQueen. It's a basic analysis of fairness based on the timing, and at some point in time, this legal theory will, arguably no longer apply, and generally, because it's using this retroactivity that the notice will have arguably been given if McQueen is that notice given. I mean, there's something about that, too. It's not like it's the affirmation of it at the appellate level gives it any significant strength going forward for any length of a period of time. It would probably be the most equitable thing to do. It's almost like a amnesty, right?
Right.
That could even be used retroactively for all the people that got caught up. That would be the play. There you go. Let's get some of those Court of Appeals judges on the phone.
Yeah, that's a great idea.
Right? Like they'll say, okay, here we go. We're gonna lay it down right here. Let me be the Court of Appeals judge. We are going to affirm the opinion, and we're actually going to do a declaration that this law, those that were arrested under these principles and charged with felonies, they apply this ruling retroactively to those judgments against them for due process principles in an effort of amnesty to eliminate all the terrible convictions that took place where they heard judges say things like, ignorance of the law is no excuse.
Oh, God.
They could, what?
It's such a cop-out.
They're ignorant.
Such a cop-out. It's like, no kidding. That's another real basic principle, and don't think I'm trying to play dumb. Don't think that my due process argument is ignorance of the law. That's insulting.
The other thing that I like a lot is if you have some of these dispensary cases and the police try to refer to the law, even if they refer to McQueen, even if the decision came out after the culpable time, but the reference to McQueen is really like an insulting reference if you're sitting in criminal court, right? Because McQueen is a civil injunction. There's no
a nuisance.
There's no felony charges pending. There's no liberty at stake. There's no forfeiture action. It is a going to court, leaving court. No bond needs to be posted. It's a completely different liability. So when they reuse the word McQueen to describe a legal principle, when you're talking about people that are looking at prison time or jail time or what have you, it's really not a fair assessment, because when they're going to use McQueen, there should have been a notification and a letter to shut down and an injunction filed or something, instead of the arrest. But do you guys, so what do you think, Paul? Let me ask him, who was the prosecutor? I know it was Schuette's office, but who was the assistant?
Assistant was Paul Cusick. He used to be Wayne County prosecutor, I believe.
Okay.
Somebody's trying to call
And
in.
did you get a sense that they were going to appeal? What was it like litigating with him? Was he...
It was... I mean, it's funny. I actually... I think at one point, Matt Newberg and I described it as fun, like the preliminary exam and the process of it, and kind of doing it on not a lot of time to prepare and just essentially having to be forced to start no matter what. I mean, we had discovery, we had 17 CDs and some 1,000 pages of police reports and 10 days to prepare a defense and a preliminary exam, and went in there and got a lot of charges thrown out there. But as far as getting the sense that they're going to appeal, I think they have to. I think at least he has to, because this is the second case he's lost like this recently. I think that they have the resources to do so, so it's not as much of a consideration or as an intense process as it would be for, let's say, the defendants to have to appeal. So I think they will, because, I think Schuette will look at it and say, well, this won't stand up against, my Court of Appeals, and we'll see what happens. So, but whether or not the assistant himself wanted to appeal, I think he was just doing his job. I mean, it was not a very, and Michael, you can appreciate this. It wasn't a very contentious prosecutor. He was, he didn't make problems. He wasn't resistant, or, he wasn't trying to stonewall. He was friendly. He was nice. He was helpful. He was, he disclosed everything he should have and gave us stuff that he said, hey, we have it, and if I have it, you should have it. So it was very fair, and it was, I've dealt with worse.
When that happens, that you really appreciate it. It makes the profession so much easier, instead of, the opposite of that. I had a recent experience in Van Buren Township where it was a, real intense battle, but every moment outside of the courtroom we were total professionals with one another, and and it's good when you can develop those rapport with prosecutors, right, and then you realize how great that is when you go back to the home base sometimes. But
right.
Paul, you mentioned that there were two cases that he had lost. What was the first case?
There was the first. It's a Ingham County case. It was I want to say it was somehow connected to Hydro World. There were 4 defendants, and the case was dismissed at the preliminary exam. And then at the appeal to the circuit court affirmed the district court's ruling that it was an ultimate ex post facto violation. And I want to say that one of the defendants' last names is Corbin, if I'm not mistaken. But that was another issue. But I expect them to appeal. People, prosecutors, I expect them to appeal because they want to keep their jobs. They want to say, "Oh, it wasn't me; it was the judge."
Yeah.
So, especially, especially in the more contentious counties. Or
so it's interesting. So what's next for you guys? You're just gonna await the process. Any final thoughts in terms of what you expect to happen in the coming months or year?
I'll probably get a phone call or two letting me know whether or not. Actually, no. I expect I'll get a postcard in the mail letting me know that an appeal has been filed. That's about all I anticipate. But other than that, it's better to win now rather than have to, lose and fight on.
Oh yeah,
but
you take them when you get them, and you
exactly.
make sure it's all the way through to the other side. Jim and Deb, any final thoughts? I'm sorry I didn't hear more from you. What are your thoughts reflectively here? What would you care to share from this experience up to this point?
Well, we feel like Charlie Sheen were winners. But besides that, we're moving forward. You guys know, we filed a lawsuit last year against the State Attorney General's office, last November. We were filing it when they filed charges against us. So that lawsuit's still going. Our lawsuit at that time against Schuette was that violation of due process. And judge pretty much gave us the goose with the golden egg when she signed the order that we were denied our due process. So we're going to continue with that lawsuit. That lawsuit was filed against Schuette, 4 prosecutors of Tuscola, 69 police officers that raided us. We had 30 employees at the time they raided us. They put AR-15s to their heads, put them on the floor. We were robbed. And we're going to continue to fight. We're in this for the battle. The history with Jim and Deb, Paul Talinda, Rick Ferris, Rick Thompson, Jamie Lowe, Ben, Green Bees, Ryan Berser, I can go on. We started MAC, and a few of us that started it, really took a beating for it. But we did it for the medical marijuana community. We should have picked a better attorney than what we did when we picked Mac, but we did interview him, and we thought Razor was the best at the time. Well, guys, sometimes roses smell like poo-poo. And we should have went with Paul Talinda all along. But I know you got Rick Thompson sitting in there. I know you got Jamie Lowe. They're both very, very good friends of mine and Deborah's. And so is Rick Ferris, Robin Snyder. We fought this fight. And the first time I met with Rick Ferris for the MAC, it wasn't even a MAC. I told him then I would not let the government tear this law apart that the people voted for. And that we had to do something, we had to do it now, we had to put our money in the lobbyists and get to Lansing. Find out where the bodies are buried. Well, they took down both of us. As you all know, I had a big hit, and they thought we would crumble. And while I was gone, they decided to come in. But my family is 100% behind this. My wife is too. But when your employees get AR-15s put to their heads and forced to the floor, and then told they're bad people because they were helping the guy that was dying of cancer, this ain't right, and the public knows it. What I got to say is if you're being charged, go to a jury. Don't accept a misdemeanor charge that they charge you for felony and then kicked it back to a misdemeanor, because that misdemeanor charge will still put you in prison a year from now when they come back to do you again, because they will. Take it to jury. Jury will not find us guilty. We're good people. We're neighbors. We're friends. We're relatives. It just won't happen. It's over. The medical marijuana is over. And I was prepared, and my family was prepared to take this to jury. That's what I wanted. To today, I still want a jury. I still don't feel vindicated because I know my community would not have done this to me. Jamie, Rick, I love you both, and I'm glad to have you both as friends. Thank you.
Thank you, Jim.
Thank you, Jim.
And Deb, too. And Doug, and all the rest of the guys.
All right, listen, really great talking to both of you guys. I'm going to let you go. We're going to have to get some other callers coming in. But really, congratulations on a really phenomenal victory. And for staying the course, we talk about how difficult it is to endure the process. Examples that we have day-to-day at Camorran Law. And I think we've flushed them out here and what it really takes to get to this point. And there may even be some more fight necessary, but there's no question that the will is there. So congratulations again, and what a fantastic victory. And you're going to have to keep us updated and get you back on to let us know what kind of reactions take place out there.
Great.
Thanks, Michael.
Thanks, Michael. Thanks,
All right,
Paul.
guys.
Thanks,
Paul,
Jim.
we'll talk to you soon. Thank you once again, all the medical marijuana community. Thank you. Thank you, Green Trees. Michael, you're the best. Keep up the hard work. Bye-bye.
Bye, guys.
Shuri, shuri,